What's up, everybody? Welcome back to another episode of The Lawyer You Know. And I'm incredibly excited to have Judge Carol Erskine come on and talk about what it's like to be a judge in Massachusetts. She was a judge there for a long time. She has a lot of thoughts on Karen Reed's case and just generally what it's like to sit on the bench, weigh the decisions, and make the decisions. Sometimes that can be very tough, and some decisions that can end up in some very high profile cases. She's told me to call her Carol. I'm going to do my best. It's probably going to still come out as Judge or maybe Judge Carol. We'll get there. But just so everybody knows in the chat, if we get that comfortable and informal, that's why. I'm really excited. I hope you guys are too. We're going to learn a lot today. Let's get to it. Carol, thank you so much for joining us today.
Well, thank you for having me. I'm really excited about this. I don't know that I could actually count the number of people on X that told me this is the place you have to speak out. And I'm happy to do that because, obviously you spend a lot of time educating people about the law and the courts. And hopefully I can get a little bit of that done, just sort of educating people about how it works, how judges view cases, and how things happen or don't happen in Massachusetts.
Yeah, and I want to start there just so everybody knows who we're talking to. Can you give us a little bit about your background and experience, how you became a judge, how long you've been a judge, where you're a judge, before we get into kind of the specifics of what happened in Karen Reed's case?
Oh, sure. Well, I practiced law, I think, for about 12 years. I got into law late, actually. I was actually teaching in a health division in a community college and then went to law school. And practiced in different areas, but doing a lot of child advocacy, a lot of mental health law. I represented hospitals in mental health cases, and did some criminal. And then I was appointed to the bench by the governor. And when I met with the governor said, we need people in the juvenile court, to be helpful to families and kids and to address some of the issues that come up regarding children. So, that was quite an honor for me. And I had done a lot of child welfare work in the juvenile court. So I was appointed to the bench. I retired in 2023, so that means I was on the bench for 22 years. And in the juvenile court, I just heard cases every single day. So, the focus in my life has been child welfare and the child welfare system. I've been somewhat critical of the judiciary, the legal system, and the child welfare system in Massachusetts. That hasn't exactly inured to my benefit when it comes to people in the system. I think I'm viewed as somewhat of a rogue judge, and I'm okay with that if I can make changes in the child welfare system. But in my court, it was an inner city court. For 15 of those years, I was the first justice, which is, if you look at Judge Cannoni, they call her a RAJ, a regional administrative justice. You hear cases, but you're responsible for case assignments, for the administration of the court, budget-related issues, personnel. So in my court and in the other courts, they call that first justice, and I was the first justice, I think, for 16 years until I retired. But it's an inner city court that had 5 satellite courts around the county, but mostly I sat in the inner city court of Worcester, which is the second largest city in New England. So it was a very, very busy court. It's a very urban court, and in that court, I heard criminal cases, which are divided into 2 types: delinquency cases, where the maximum penalty is detention, putting someone in a detention unit or a commitment to the Department of Youth Services to get services. And then, and other dispositions like probation, if you're not going to commit someone to the Department of Youth Services. But the other type of juvenile cases are youthful offender cases, and those are teens who have been indicted by a grand jury. And so in those cases, the rules, like you saw in the Reed case, the same rules apply. It's generally the rules apply in all cases, but there are special rules when people are indicted. And in my case, youthful offenders are kids who were indicted for serious felonies, like firearms cases, shootings where there wasn't a death because murder cases are heard in the Superior Court unless the alleged murderer is under the age of 14, which doesn't happen very often. But those cases are usually firearms cases, shootings, sometimes rapes, robberies, can be home invasions, where there's a decision by the district attorney to indict those kids. And what that means in the juvenile court is that I would still hear those cases. It would be a 12-person jury. All the same kind of instructions apply. But I had the option to sentence the defendant to a juvenile facility until age 21 or directly to prison or jail. And so there's a lot at stake in those cases. And every day in the juvenile court, and in my world, it's a busy place of arraignments and pretrial detention hearings, dangerousness hearings. So that's the criminal side. The other side of the court are civil cases, kids who are runaways, sexually exploited kids, kids who are in need of mental health services. But the majority of cases in my court were parental termination and child abuse cases. When I left in 2023, there were over 1,000 open child abuse cases under my jurisdiction with the other 4 judges in my court. And in those cases, basically what we're hearing every single day, and there are many trials related to these cases, long evidentiary related trials, involve serious sexual abuse, physical abuse, fractured skulls, broken bones, kids who have been starved. And in my years on the bench, I think I heard 4 or 5 murder-suicides, which left children behind, that I would have to put those kids in state custody, substance abuse, domestic violence. It's very, very serious stuff and requires a lot of judicial attention, listening, like people probably saw in the Reed trial, but just listening intently to what's going on, handling objections, making sure you're hearing everything you need to hear, deciding motions in limine. So that's pretty much the general day, and that's pretty much what I heard for over 20 years.
Yeah, and I appreciate that, and that's kind of the background that's necessary to understand how different a lawyer's job is versus a judge's job, and what you do day to day and the decisions you have to make, the research you do, and what you have to all have in your head before making very important, big decisions that affect people's lives very considerably. And sometimes lawyers can be critical of judges. Usually we try to do it in a very respectful way to still respect the position and the court and the bench and the person as much as we can, even if we disagree with them or don't like them personally. But you're sitting there, you've made these decisions, you've weighed, Sixth Amendment rights to a fair trial, witness rights, victims' rights, all come into play when you're making these decisions. And you ended up commenting on some of Judge Cannoni's decisions and some of the Sixth Amendment rights for Karen Reed. What grasped your attention about this Karen Reed case?
Well, aside from the evidence which people debated, thousands and thousands of people debated, that really wasn't what I was watching it primarily for. I mean, I was just looking at the process. And so, the issue of fairness, which which you hope that all judges have as a priority, because in cases that are criminal cases, there's only one person in the room. And just like in this case, there was one person in that courtroom who had a Sixth Amendment right to confront witnesses and who had a right to what the Sixth Amendment says of compulsory process, meaning that every defendant under the Sixth Amendment has a right to call witnesses and confront witnesses and elicit favorable testimony. And I think as many people know, the Sixth Amendment is actually a prohibition on the government. It just tells the government, you cannot stop someone from calling witnesses. You cannot stop someone from eliciting positive testimony. You cannot stop someone from confronting witnesses. That's what the framers intended 200 years ago. And it rose out of the fact that when those in America were still under British rule, they were absolutely not allowed to call witnesses. They weren't allowed to put on a defense. And so that's the historical perspective of it. But it's ever present every single day in a courtroom. Every single day you're thinking about this. Am I being fair? As you said, you have lawyers, just presenting evidence on both sides and you're listening to it. And ultimately, someone's not going to be happy with your decision. If I was hearing a motion to suppress on a criminal case over Miranda issues and I decided to suppress it, well, the prosecutor wasn't going to be happy. If I decided I wasn't going to suppress it, then the defense attorney. So, you go into it understanding very clearly that there are always going to be people, lawyers or other people, that aren't going to be happy with what you decide, but you make the decision based on how you're viewing the evidence and always with this underlying view, especially in criminal cases, that there's only one person, as there was in the Reed case. That one person is Karen Reed. It's not the judge, it's not the prosecutor, it's not the defense attorneys, it's not the journalists or anybody watching. There's only one person that had that Sixth Amendment right. And so when there were times that it seemed to people that there was an uneven playing field, what plays into that is the fact that she's the person whose rights supersede everyone else's rights. And so, as you heard at times, Hank Brennan would say, we want a fair trial too, and the Commonwealth's entitled to a fair trial. That may be so, but what they don't have the same entitlement that Karen Reed had, related to her Sixth Amendment rights. And so those were the things I was concentrating on.
Yeah, and it's funny, just so everybody in the chat knows, we've never spoken before outside of scheduling this and 5 minutes before, just pleasantries. And it's amazing to hear you say that. I love to hear you say that, because that's something I talk about all the time. And people sometimes get frustrated when you talk about how the most important person and right in every criminal courtroom is the Sixth Amendment right of the criminal defendant, not the prosecutors, not the witnesses, not the judge, not the public. All of those things are important and can come into play. And when judges make analysis or do their analysis, but especially when we've seen some high profile cases, like, I don't know if you know about the Koberger case in Idaho, there were a lot of motions filed by, all of the media companies, and we want cameras in the courtroom, and the judges balancing things. And all of that is really important, but all of it is second to making sure the defendant gets a fair trial, that Sixth Amendment right being so important. So with that in mind, and that's what kind of got you interested in this case, where did you see problems arise for Karen Reed throughout her process of these criminal? I don't know if you watched the first trial as well. Whenever you picked it up, what problems did you see coming up?
Well, I think I identified, at least for me, problems that I saw and things that I might do differently. And maybe, a lot of, as a lot of decisions judges make, especially on motions, is discretionary, but it's based in the law. And basically you have someone file a motion and then you listen to both sides, you read the law, you meet with, and I'm sure Judge Cannoni did with the law clerks, or in Massachusetts, they now call them research attorneys. So you just have these people standing by to sort of research it and then put it right in front of you. It's not like, I don't think she went back into, they don't call them chambers, they call them judges' lobbies in Massachusetts. I don't think she went back to the lobby and had to write every single thing. I mean, that's what research attorneys are for. But when I looked at it, I think one of the things I really focused in what had to be related to decisions regarding experts. And so for maybe people listening and watching this, what I'd ask people to do is sort of look at things side by side, rather than how we looked at them during the trial. So during the trial, so one of the main examples, and I think things that I posted about, was related to Jessica Hyde. So take a look at Jessica Hyde and then line it up or juxtapose it with Dr. La Posada. And so you look at the decisions that were made in those cases, and having to do with impeaching those witnesses. In other words, calling attention to the credentials of that person. So Jessica Hyde is going to testify. She's going to testify about phone data, and the person with the Sixth Amendment rights is, through her lawyers, is wanting to cross-examine her about the fact that she was declared to be unreliable related to testimony around the phone. And so I don't think there could be anything more relevant. So just to step back in terms of how you hear witnesses, and I've heard hundreds of expert witnesses, especially in child abuse cases. Was there sexual abuse? What's on the x-ray? Are these fractures? Are they not fractures? It all starts with the basics. What's your name? Where did you go to school? Do you have a bachelor's degree? Do you have a medical degree? Do you have certifications? They turn their CV into the court. And have you ever testified in another court before? Which wasn't really highly relevant to me because there's always a first time that someone's going to testify.
Right.
But in the case of Jessica Hyde, they wanted to impeach her credentials and her reliability based on the fact that she had been determined just months earlier in Maryland regarding a phone case, determined by a judge that that her testimony was unreliable based on a Daubert analysis, which underlies all these expert witnesses, unreliable. And then the judge makes and then Hank Brennan then says, this isn't right. It's too late in the process. And this is only to malign the witness. It has nothing to do with maligning anybody.
You could say that about any attack on credibility, right?
Absolutely. And you certainly could say it about the way the dog expert witness was treated, and at times Dr. LaPosada. So the judge makes a decision in favor of the Commonwealth and says, you can't bring that in, it's too recent. Well, I have two things to say about that. First of all, you want something to be recent. You don't want something to be 20 years ago. Like in my view, this whole issue of Dr. LaPosada and this 20-year-old nightclub fire, first of all, was it relevant? And secondly, the time factor was there. So Jessica Hyde, for some reason that I couldn't understand, because if it were in my court and I had someone that another judge had said was unreliable, boy, I'd want to know about that, and I'd want the jury to know about that. So the decision is against the defense, and then Dr. LaPosada comes in, and what do? The defense objects. Why are you bringing in this Rhode Island station fire? It's not relevant. It was 20 years ago, which is the more important aspect. You want something to be recent, and it was totally irrelevant. Completely irrelevant. But they allowed it anyway to try to impeach her. And to me, that had more of a, I guess if you wanted to use Mr. Brennan's words, more of something kind of maligning a witness. I just didn't see the relevance in it. Yet the judge declared that it was relevant, even though it had nothing to do with what happened at the nightclub in Rhode Island. It was a fire, it was a possible arson or negligence, but it really wasn't relevant. So you have this one witness, when you put these two together, you have this one witness by the defense who, in my view, if it were me, I absolutely would have allowed them to cross-examine on that. It's on reliability, and it's on an issue that's not only relevant, it's almost exactly the issue in the case. It was related to phone data. So I was stunned by that. And I did post about that I thought it was a violation of Karen Reed's Sixth Amendment rights to confront witnesses and to elicit positive testimony. But as I talk about it and sort of preparing for this, what I wanted people to see is when you put it side by side, then you have to make a decision about whether or not you think it's fair when you look at, oh yes, this 20-year-old Rhode Island station fire can come in, which was interesting because even in that case, that she wasn't declared unreliable by any kind of a court. And not only that, there's almost a sense of, did the prosecution do its homework and find out the fact that in Rhode Island, like Massachusetts, medical examiners are not called to the scene of a death. And so it just made it even less reliable, yet it came in. And so I think you can understand why people see some unfairness, especially, I think, when you start to compare cases. And this happened, I don't know if you want to go on, this happened with Burgess too, which I also had an issue there.
Yeah. The comment makes complete sense. And from a lawyer's perspective, I appreciate these thoughts from a judge, because from a lawyer's perspective, one of the most important things I look for in a judge I like trying cases in front of is that they're consistent. to where if they're going to do something with one expert, we can expect it with all the experts. And I think that was one of the problems with Judge Cannoni throughout the entire process. And you've pointed out one of the inconsistencies. Another one that I noticed is, one dog bite expert that seemed to have a lot of experience had to be voir dired multiple times, even after testifying in the first trial. Another dog bite expert, rubber stamped. Come on down, you can testify. Didn't end up getting called. But what do you see with things like that? When you're a judge and you're making these decisions and everybody wants all these experts in, and of course, everybody's going to object to every expert. How do you deal with being consistent in making your rulings?
Yeah, I mean, you have to be consistent with the law. And so that's how it is. I mean, you have to take the facts, as you know, the facts are always different.
Mm-hmm.
And so I used to say when I would hear motions to suppress, are you telling me there's no Supreme Court case or Massachusetts case that hasn't addressed this one issue, this factual pattern? But the reality is there are so many factual patterns that you have to look at them differently. But what you have to do is apply the law consistently. So you look at this issue here with, for example, with Burgess.
Mm-hmm.
Okay, so you have a witness who's coming in, and one of the main aspects of declaring someone to be an expert, because anytime there's going to be a witness to testify, as soon as the voir dire is over, if there is a voir dire, and sometimes there isn't a voir dire, the prosecutor or the government, whether it's in a termination of parental rights case or whatever, will say, Judge, I'm asking you to declare this witness as an expert, but not just an expert in something.
Mm-hmm.
So in my case, it would be, I'm asking you to declare this pediatrician as an expert in pediatrics. And then I would have to decide when they would say, and in child abuse, whether there was enough expertise in child abuse, or if it was a sexual abuse case, is this person an expert in sexual abuse? So every time there's an expert, not only does the judge have to declare the person an expert, but they have to declare exactly what they're an expert in. And so this is what you're seeing with these witnesses. So you have, let's say, Burgess, who comes in to testify. I don't think there was a voir dire, right? No voir dire for Burgess. I was stunned by that because everybody knew ahead of time that his resume on the Aperture site, and I'm sure the Commonwealth knew it, didn't match what he was going to say. I mean, he changed his resume to say that his education was in progress because, you can't lie to a court. So he was going to testify and this information had been found out. But you're coming in with an expert witness who's already lied about something, and not only lied about something, but has lied about his resume. And, people are posting, he didn't lie about his resume. He said it was pending. Yes, he did at the trial, but he was declared, the reason that he was hired by Aperture was for his expertise and certifications and for his resume, which said he had a bachelor's degree in two things, mathematics and business management. So, if I had an expert who was testifying in my court and they were going to testify about a radiograph showing a fractured skull, and then I found out that the person was a medical doctor, but not a radiologist, but had put that they were a radiologist on their resume, I wouldn't even allow them to testify, because that misrepresentation, it's a lie. And even though it's a bench trial and I'm making decisions, I would say to myself, I can't trust this person. This person already lied. So why am I going to hear this?
You're the gatekeeper of reliability as the judge. So if you find that somebody's not reliable, what we don't want is to allow people to go trick a jury and somebody that's willing to lie or do things that is inappropriate that you have declared as the judge as an expert, because the jury is not going to know that. Or if it's a bench trial, the judge, you have to consider that expert testimony if you let it in. So you're explaining the gatekeeper role perfectly. That just wasn't done in this case, I feel like, appropriately.
Yeah, I mean, I think with Burgess, I was very surprised, very surprised. There was this whole notion that kept coming up during the trial, and I don't know if you heard it, but a lot of people posted about it, that when the defense would object to someone like Burgess or someone else, and the judge would allow it to come in that case, without a voir dire, she would say, I'll allow you to engage in a robust cross-examination. I was actually stunned by that because I would ask myself this question in my head. Tell me, under what circumstances is someone not allowed to engage in a robust cross-examination? So it comes, it
Exactly
came
what I
across,
said. Exactly
yeah.
what I said.
I mean, sort of came across like, well, I'm going to give you this opportunity because I'm allowing the prosecution to bring this guy in whose resume, as of this day, on Aperture is a lie. And not only that, I'm going to allow him to testify. And by the way, I'm going to allow him, even though he has no bachelor's degree in anything, but not only am I going to allow him to testify based on his accident reconstruction certifications, I'm going to let him testify that as to the cause of injuries to John O'Keefe. Stunning. I was stunned by that. But it's her decision. But when you compare it for consistency, then you have Dr. Russell and Dr. Leposada, and 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 she's of course allowing them to testify. I mean, there was no question. I mean, it's one of the few things I think I talked about um, on court TV that I had never seen or heard of a witness that was so qualified as Dr. Russell. Both of them incredibly qualified. And so first, the judge allows the nightclub Rhode Island thing, which in my view, if it were my court, I would have viewed that as irrelevant. But then it's like, well, I'm going to allow them to testify, but I'm not going to allow Dr. Russell, who's like the dog expert of the century, in my view, but I'm not going to let her say it was a dog bite, but I'll let her say it was an animal bite.
Yeah.
And so then there are these limitations. And yet I'm comparing that, where, you have someone who can say that those injuries on the arm are from a dog bite. No, I'm not going to allow it. And then there were some limitations as well. Limitations were put on Dr. La Posada, and yet no limitations are put on this witness who has no resume that shows an expertise in anything related to injuries, and he's allowed to testify. As you know, they call it the ultimate issue. The penultimate issue is guilty or not guilty, but the ultimate issue, which was, was there a collision, and was John O'Keefe, hit by a car. I don't comment on the evidence. I left that, as everybody knows, any post that I made, I said, this is up to the jury. I'm never going to comment, even though people ask me, do you think guilty or not guilty? But the notion that those experts, Dr. Welcher and Mr. Burgess, could actually give an opinion as to what caused the injuries, that the ultimate injuries were caused on John O'Keefe. That's one of the ultimate issues. Yet you have these two doctors who did a great job, and it came across, in terms of what the ultimate issue was. But when you compare the two side by side, you have to ask, was it consistency? Was it fair? Or, as you say, was it consistent across the board, consistent with the law? And that's the way I looked at it.
Yeah. And when you come to making these decisions and you're trying to be consistent and you're looking at it, and regardless of what you and I can say about Dr. Russell and La Posada, it seems so very obvious. Some people that maybe haven't seen a lot of trials, haven't searched for experts, haven't interviewed and hired experts, haven't declared people experts like you have. Maybe it's not as obvious to them how different these experts are and how top echelon these experts are, but it seems so obvious to those of us that have done this for a living and are still doing this for a living. Not only did Judge Cannoni rubber stamp the less qualified experts and require voir dire of the more qualified experts, but she also went further. And you've written orders before. And in your orders, have you ever used the language Judge Cannoni used to say, this is a close call, and here are 5 issues that the Commonwealth could use to cross-examine Dr. Russell, where I think she's pretty weak? Have you ever done things like that in an order?
I was stunned by that. And no, I've never done anything like that. And the fact is, the reasoning behind it being close, it was just amazing to me. And again, compare it to Burgess. I mean, was it even close that he was qualified when his resume on Aperture was a lie? I mean, it's absolutely stunning. But did you even have a voir dire? No. What you had was, again, a robust cross-examination, which is allowed for the defense to do on every witness. And that was sort of the excuse. Well, I'm going to allow a robust cross-examination. I'm thinking to myself, what does that mean? Like, that's not something that I could picture myself saying, because every defense person is allowed a robust cross-examination.
It's not
And
one of
so,
the Yeah, it's not one of the listed remedies. A listed remedy is you strike the witness, you limit the witness, you sanction somebody. Like, those are the remedies that are available to judges if they find somebody lied or did something wrong. It's not, no listed remedy is I'm going to allow you to cross him really good. You can go
yeah.
hard on cross. Like,
And you said it, I think, kind of the right way. I think, I'm trying to be judicious about the way I say things, but
sure.
but of course, I think you're right. I mean, I just couldn't find that. When I read that decision, and it said this was a close one, I was shaking my head and thinking, how is this even close? This is a woman that has 30 years of experience. She's written articles about dog bites. She's probably seen 1,000 dog bites as an emergency room physician. She worked with a police department. I mean, her credentials were impeccable. I mean, impeccable. And so, again, all I can say is how I viewed it. I mean, how the judge viewed it, that's her discretion.
Mhm.
Just like every other judge has discretion, she can view it any way she wants. So I'm not going to criticize the fact that, she exercised her discretion. That's what you expect judges to do. Just from my standpoint, I just didn't see it that way. I didn't see that it was even close. And then this sort of going on in the decision. But the defense, defense could do this and can do that. Sort of, it was almost like instructing the defense on how to approach this, and maybe in a way that wasn't so overt, but I mean, that was just a feeling I have. I'm not accusing the judge of anything, of course, because she has a right to make the decision any way she wants, but it just seemed like there was a lot of guidance provided there. That's just not something I would have done. I just would have decided. I mean, in that case, from my view, and I've spoken about this very issue publicly before, I mean, she was probably one of the most qualified witnesses that I had ever seen. And so to put restrictions and limitations on the testimony was just not something I personally agreed with. Other judges might disagree with me.
Yeah, and that's the beauty of judicial discretion, which I try to explain it to people as best as I can, but it's really like mom. It's like mom's going to make her decision. She might not always be right, but it is mom's decision to make in most circumstances in a trial, right? And you may disagree, but
Right.
it's her decision to make. Additionally, to talk more about the judge's comments and what comments you may make, Judge Canoni intentionally and purposefully decided to make comments on the record about attorneys throughout this process, specifically having grave concern about certain things the defense attorneys did, finding that they violated Rule 14. These things that she said about Attorney Jackson and specifically the defense attorneys, I'll just say it because she didn't really do it to the prosecutor at all. Those things can follow an attorney. And lawyers can then cite that if they write a motion to you and say, hey, Tragos over here in, Idaho, this judge said it. You don't know who that judge is in Idaho. You have a record of a judge saying you're not reliable or you violated this intentionally. Talk about how big of a deal that is to you as a judge to put something like that on a record about a lawyer and how careful you would be to do that.
Well, I'm glad you brought that up. That was a huge, huge deal for me. And I think I might have commented about it, but I didn't want to, get people all fired up about it. But I will say I was fired up about it because when you're on the bench, you have to be so careful about what you say. And you always have to remember that there are rules about what judges can do and not do and what they can say and not say. And they can't, judges cannot say things that, bring about any kind of view that they might be biased. When I posted about it, I called it the grave concerns shot heard around the world. And that's sort of was my description, and that's how I wrote it. Because in my view, in terms of judicial discretion and the proper way you have to carry yourself on a bench, to me, that was improper. And the reason I say that is, first of all, it didn't have to be public, because it was surrounding a potential violation. So that's when you bring judges back into the lobby and you sit down with them and say, we need to discuss these improprieties, because that's not really related to the evidence in the case. And so if you think there's some impropriety, you can report it to the Board of Bar Overseers. You can report it to the outside agencies. But to put it out there in front of essentially millions of people, and it also was the way that it was said, I have grave concerns. And you'll notice that she got off the bench shortly after this, which maybe it was a recognition of, maybe I shouldn't have said it that way. And this sort of, degrading comments maybe about the lawyers, and in particular Jackson. I think her feelings of I don't know what to call it, animus or whatever, towards Jackson came out at times during the trial. At least I felt that way. Maybe other people disagree with me. However, that I think was improper. And I can't even imagine myself being on the bench and saying something like that, because, like you say, something like that can follow. And a lot of what was being said at that time hadn't been investigated, hadn't been vetted. So you have this comment that's coming out prematurely that's, just has this effect, this very negative effect coming out that millions of people are hearing.
Mhm.
I thought it was improper, and it's kind of set a tone, and it also said something. It causes you to ask the question: is this judge a neutral arbitrator if she's saying something like that? And that's what has to happen, because until you are making a decision on something, you have to be a neutral person and listen to the evidence. I was, it's hard to criticize another judge, and I've been criticized for criticizing, judges at times in cases that I felt did not show, maybe proper judicial, the proper judicial manner, or whatever you want to call it. But I have to say, this was something that really I was taken aback by. I just couldn't believe it. And you're right. I didn't think of it in that term. Exactly what you pointed out. This is something that other people can use later on. Just having someone just make a declaration like that. And the reason I called it, the way that I did was because it was heard by everybody. Every newspaper published it. It just I termed it as the sort of the shot heard around the world. And in my view, this is something that violates the very constitutional tenet of the Sixth Amendment rights. A lot of times I focused on that. I teach constitutional law, so I have a heavy focus on it. And a lot of my viewpoints were premised in that.
Yeah, you might not be able to believe this, but I've been criticized too for reacting to what lawyers and judges do and say, and try to say might be how I see it or how I do it differently. You opened up saying every single time there's going to be a lawyer that walks out of the courtroom disagreeing with the judge. That's not a surprise. That's how it is. And I think as long as you do it in a respectful and gracious way, which I think you've been more than that throughout this process, this is the only way for people to learn. I don't want everybody in this chat, everybody in Massachusetts, to walk away from this case thinking every judge is like that and that every judge acts like that or sees it the same, or because people are going to, one of the points of this channel is to not be afraid of our judicial system, but to understand it and to walk in and understand what should be happening. What are your rights? What is a lawyer there for? What is a judge there for? And I think you've done a great job of explaining and defining so much of what a judge is supposed to weigh and listen and do throughout the process. And when you talk about maybe it feels like a judge has a lean one way or the other, or loathes a certain attorney, so many people have asked questions about, 49 out of 49 objections sustained from the Commonwealth and overruled from the defense, 50% or whatever it is. Did you ever keep track or feel, because we just got done with the NBA finals, one team sometimes has a lot more free throws than the other team. Sometimes it just happens, but have you ever felt in a trial that, one lawyer was just doing a better job at objecting and that's why they won? Or, have you ever felt yourself in that kind of a situation where it felt like you were sustaining every objection from one lawyer and overruling everyone from another?
Well, I think, yes, I think, we're always in that situation. A lot of it has to do with the competencies of the lawyers. I
Exactly.
mean, there are times when I'm sitting there on the bench thinking, I cannot believe he's not objecting to that.
Yes.
Or, and you're thinking to yourself, oh my gosh, how much more hearsay can I, can I listen to without someone objecting? Because, I think probably one of the most important things you can do as a lawyer, and something that was so important to me, was just sort of keeping up with the rules about hearsay and objections and what they are and when they're proper. And as a judge, every year they put out a book in Massachusetts on rules of evidence, talking about the most recent cases. And that's just something I read from cover to cover every year. So I would know, if there were any changes and how to react to objections. I think, a lot of it depends on really how seasoned maybe a lawyer is, or how much they're in evidence. But I will say, related to this case, I mean, it's really hard when you've been a judge and you're hearing people objecting on a huge case like this, and you're thinking to yourself, just no. So one thing people have asked me a lot about is, why didn't during the trial people say objection, hearsay, or
That was
objection,
on my list. I'm glad
not
you went
evidence?
there. Let's hear it.
Loads of people ask me that. Well, the reason, I mean, in every case where there wasn't a jury, if it was a non-jury trial where I was hearing the case, or if it was a child abuse and neglect case, in every single trial, I would say to the lawyers, "What's your objection? What's your objection?" And sometimes it would be what I used to call the "I don't like it" objection,
Exactly.
where they couldn't point to, it's hearsay, it's irrelevant. It calls for, a conclusion without a foundation, and uh, and so it's you just are asking people, what's your objection? But in a jury trial, the issue that comes up there is, you're asking people who don't have any connection to law whatsoever to sort of understand things and then draw some conclusions from it. So when you're objecting, and someone objects, and says, objection, what's your objection? Facts not in evidence, then juries are going to make conclusions about what that means without really understanding exactly what that means. And so in jury trials, one of the reasons, and I think it probably caused so much aggravation for people, like every 5 minutes, the lawyers are going up to sidebar, right, and talking to the judge when there's an objection. And basically what they're doing at that moment is they're putting on the record what their objection is. Look, this is, speculation, there's no foundation laid, and they're doing that to preserve the record for appeal. But they're not going to do it with a jury trial, because you don't want to confuse the jury with what some of those, terms mean. It's an improper hypothetical. Well, I mean, how are you going to explain what that means? It's a hypothetical that was created, but there weren't facts and evidence, which is a basic requirement for a hypothetical. So they go up to sidebar and they say, we want to put our objection on the record. You're allowing this hypothetical to come in, judge, and the prosecutor or the defense attorney is using facts that aren't in evidence. So that's what's happening a lot of times at sidebar, and why you're not hearing. But what's problematic about that is, at the time, as Alan Jackson, I don't know if you heard his interview, but a very brief interview he did on Boston radio afterwards,
Hmm.
and saying, that there had been, I think, 49 objections, and they were all sustained. Objection sustained, objection sustained. A lot of people heard Judge Cannoni say this to the lawyers: ask it another way. I'm like, I have I don't know if the lawyers knew what that meant, but I have to tell you, I didn't know what that meant. I assume that it meant, as you would know as a lawyer, objection maybe calls for facts not in evidence, or it's a compound question, and so sometimes you have to ask it a different way. Or objection it's leading the witness. If you're asking a question, if it's your witness, you have to ask, as you know, a direct question. What's your name? What did you do next? And then what did you do? You just testified that the car ran into a tree. What did you do after that? You can't say, and after the car hit a tree, isn't it true that the driver came out and said it was his fault? You can't lead a witness except on cross-examination. And so that happened a lot in this trial. I mean, those rules were broken tons of times, but there's only so many times that you can object without, I think, annoying the jury.
True.
And so, I think they're very careful, and I'm sure, as you know. So, all these 40 some odd objections, I'm listening to it and I'm thinking, geez, I was a judge for, 20 years. I heard, thousands and thousands of objections, and I'm hearing this judge say, ask it another way, and I don't know what that means. And so, the judge can say things like, the objection is sustained, rephrase the question or something like that. But I just didn't understand this whole concept of objection, sustained, ask it another way. There were times that Alan Jackson complained. He once said, sometimes I had to ask it 17 different ways, because there's no guidance from the judge as to what's wrong. And so, and I couldn't, even as a judge for years, at times, tell what was wrong with the question. In other words, what evidentiary rule it broke. And so it was frustrating for me to hear that, and it was clearly frustrating for Alan Jackson. And so then, you have people, online and on X saying, they're being unfair. But what is concerning is there was a lot of evidence that he was asking about that was just, unceremoniously sustained, without any objection, and then just looking and saying, ask it another way without any guidance to what the issue is. In other words, saying it's a compound question. They were asking two things, or whatever the issue was. And so from that standpoint, it had a very unfair quality to it, and clearly he was quite clear in being upset about the way that was handled, just in his sort of cynicism, which you can understand, saying, I had to ask it 17 different ways. I just didn't understand what the legal basis or the evidentiary basis was for all those objections. I mean, to me, it's unheard of that someone can object, that the district attorney, ADA prosecutor objected 49 times, and that it was sustained 49 times, really without any explanation other than to say, ask it a different way. I mean, that's not my view of how that should have gone. Again, judges may view it differently. It's just my view.
I mean, I don't know any judge that would say, yeah, you should say, I'll allow it or ask it another way. But there's just such a big difference as a lawyer if I'm questioning a witness and you just say sustained versus if you say sustained leading or sustained compound. I know I can still ask this question. I can rephrase it. If it's sustained hearsay, I'll ask it a different way, right? That's how you can ask it a different way. If it's sustained relevance, then I can't get into that subject. Like, the reason for the objection and the reason for the judge's decision leads the lawyer to know, what can I do next? Because I want to get this information out. And if you just say sustained or ask it another way, then what happens? 15 different ways I'm going to try to answer that. And that's why I kept feeling like both lawyers were asking questions so many different times, so many different ways, which again is just a judge controlling their courtroom. There are a couple things I have to ask you about that just everybody wants to know. And you said you wanted to talk about this anyways, right before we started. So I think it's just perfect because the chat's in the same wavelength as us. Let me bring up a couple of these different ways they asked it. So we have, can we ask about excluding Easter? I have a couple questions. Canoni keeping out Easter was reprehensible, total violation of Karen Reed's Sixth Amendment right. Easter should have been able to testify. There's a bunch of these. I'm going to read them off before we get your thoughts on it. And then there was a couple questions about, I'm behind, but what about keeping the police investigation expert out? I'll continue to throw questions about Michael Easter up. What were your thoughts I think you said you may have caught or you heard that I interviewed Michael Easter yesterday. What were your thoughts on his testimony? Why Judge Cannone maybe would have kept it out, and what you thought about that?
Well, it's really, and it's something that, I had made a comment about and watched his interview, his excellent interview yesterday. I mean, the issue about having an expert comment on the investigation is generally viewed as something that's not admissible because they want the jury to make that decision. And so it's considered a function of the jury rather than having someone say, this investigation went wrong. They want the jury to listen to all the facts about the investigation. And so there aren't that many exceptions to that in either under federal law or under state law. But the exceptions that exist have basically to do with whether, in terms of whether or not you can criticize police and criticize the investigation, have to do with whether or not you're asking that person is an expert to comment on things like the evidence or forensic analysis, not so much on the police, but in how the investigation was conducted, and things like forensics or evidence, if that's an issue in the trial. And so I don't think there's ever been a case where how the investigation was conducted, how evidence was compiled, including forensic evidence, and where this was sort of an alternative hypothesis in the trial. I don't think there's ever been a case where those factors applied. So there are circumstances where someone can testify about the investigation, even though it's discouraged and even though it's generally not allowed, but allowed in certain cases. And so in my view, it certainly, there never was a case that fit the criteria for where it can be allowed, because the case rested on an investigation that took place in front of the house, where evidence was collected in solo cups, where there was a video cam across the street that could see almost anything that wasn't collected, different people coming at different times, and just a lot of issues regarding the collection of forensic evidence. So in my view, I think Easter's testimony would have been allowable under that narrow exception, because that was one of the main premise. That was a main premise of the case. And so, from my standpoint, they could have limited his testimony. The judge could have limited it to that. But I think, and again, I hate to keep bringing up that pesky Sixth Amendment right, but who has the rights here? The person that has the rights is Karen Reed. And so to say she can't have this witness, and the judge had, cited case law, but in this particular case, I think it's allowed if it ties, sort of directly to the forensics and the analysis. And they, in this case, they sort of had this third party culprit kind of defense. So to me, there was enough connection that they should have allowed Easter to testify, even if his testimony was narrowly limited to those areas regarding the collection of forensic evidence and normal police processes. So I guess that's my answer. I think he should have been allowed to testify on balance. As the Commonwealth often said during this trial, that that they too have a right to a fair trial. But when you balance their right to present a fair trial with the Sixth Amendment right of Karen Reed, it's a whole different factor, because those rights supersede anyone's rights in this case. And so in order to be fair, I think they could have allowed Easter to testify under a narrow exception based on the premise of the defense's case.
Yeah, I think every jurisdiction maybe sees that a little bit differently, but I definitely think there was an aspect as well of just the way law enforcement testified in this case, which she knew how they were going to based on the first case. There was like an impeachment level to this too, where they're going to tell the jury something that's not true. And the defense should have the opportunity to come and explain how it's just specifically how they're talking about chain of custody and and things like the way they describe that and the way they throw away the importance of it is just not appropriate and not how their own procedures are. But yeah, I think it's definitely an interesting part of the case. Another interesting part of the case was when Hank Brennan, so some of the actions of a prosecutor in a case, how do you deal with it as a judge if you find either, the holes in the sweater and obviously either a major mistake or something that was just a fraudulent misrepresentation of the evidence, right? There's only two real ways to look at that because he admitted that it was a mistake. You as a judge see that's already come before the jury now. Additionally, throughout the entire time, and we've heard from jurors that some of them didn't like some of the comments he would make, like, hey, over here, or can you look at me? Or I'm not done with my question. Or because Mr. Alessi said I have to show you the transcript every time, those windups, as I called them, before he would ask his actual question, how much control would you try to assert over those if you were the judge? And over defense's objections, he keeps doing it. How do you handle things like that? I'm going to throw some questions up. A bunch of people had these questions in different ways.
Okay, so I mean, I think this is a really important topic, and I was just shocked that there was not a lot of intervention. I mean, I'll start with the fact that you have someone testifying like Dever. I don't want to pronounce the name wrong. Was it
Not
Dever?
Dever,
Not
yes.
Dever. Dever. And you have the judge allowing a witness to make comments which are inappropriate. But looking at some of the comments that were made by attorney, by the prosecutor, I was stunned, basically, by some of the things he said, but more stunned by the fact that he was allowed to say it. And so to me, I was just absolutely shocked by that. So on one hand, here you have judicial intervention coming in saying, don't make comments. And then on the other hand, you have a prosecutor making completely inappropriate comments without anything being heard from the judge. I was just stunned by that. So a lot of times when you have Alan Jackson with a hostile witness, right? I mean, she was clearly a hostile witness, and he's trying to deal with this hostile witness, and he's sort of allowed to ask leading questions. And then he makes a comment, and then receives is on the end of this sharp criticism from the judge. Confine it to questions. Don't make any statements. But then you have the prosecutor making the kinds of things that you talked about with no judicial warnings. And so, I mean, there were times I was just shaking my head, wanting to pull my hair out, saying, I cannot believe that there's no warning to a prosecutor for making the kind of statements that you just talked about. It's inappropriate. And, and sometimes almost rising to the level of misconduct, but maybe not, formal misconduct, but it was inappropriate. And so those comments, I thought, at times was so inappropriate, and oftentimes just shaking my head saying, why isn't the judge intervening? Because I would have, because those comments happen frequently, I would have said, counsel, come on up here.
Yes, that's what I was going to ask. So what do you do? Yeah, what do you do? What do you do?
Right. I would have had a sidebar and say, I don't want to hear any more of those comments. So let me be clear about that. This is an admonishment, and I want to be clear. I do not want to hear any of those comments, and have to make a decision about about when you're making those comments before a question. I'm going to have to tell the jury to disregard those statements, and that's not going to help your position. So I think when lawyers do that, and some of the comments that you talked about were highly inappropriate. And again, on balance, which is what I'm looking at in this case, when you look at the case on balance in terms of what was not allowed, which sometimes were minor infractions by the defense, and the kinds of statements that were made by the prosecution, there's a sense of unfairness, always getting back to the Commonwealth is there representing the state. They're not there to try to penalize during the process the person sitting there with the Sixth Amendment rights. Yes, they're trying a case against that person, but there are rules, and a lot of times those rules weren't followed. But more importantly, the rules were not when they were broken, the response was not equal. In other words, there wasn't the same response to things that might have been said by Attorney Jackson when he just sort of made that comment. Um, and there's this response from the judge, yet no response at times for the things that you said. There's a sense by a jury, because I've had to be the jury, because a lot of times there are bench trials and people waive a jury. There's a sense when you hear stuff like that, you're thinking, I'm not going to accept that. That's just totally inappropriate. And then you ask yourself, like jurors do, why is this lawyer being like this? Maybe their case is weak. So it doesn't help. I mean, that's the other thing I want to point out. It doesn't help to do that. It just sort of shows that someone's might be angry. Someone might feel that they don't have the advantage in the case, so they're acting out and saying that. But when you do that in front of a jury's going to question it and say, maybe this person's just not happy because they're not, they're sort of not winning this particular argument. It's a problem. But the problem I had was there's not a lot of judicial interference in that.
And that's where it comes in. Exactly what you said is what I expected her to do, what I hoped she was going to do. You bring them privately and then you threaten it publicly in front of the jury. Usually that'll keep most lawyers from continuing to do it, but it just never happened. And it was frustrating. And everybody wants to know, would you have granted a mistrial over the hoodie situation? Or would you have granted a judgment not outstanding the verdict? Or would you have thrown the case out, dismissed it with prejudice? Kind of explain what a judge's analysis there is and how difficult it is really to get there, and how you don't, if it is a jury trial, do you feel like it's your place to step in there in most cases?
Yeah, in most cases, I feel like you don't step in there. So if you can give a curative instruction, that's really the first line of things that you should do. And of course, Judge Cannoni knew immediately that she had to intervene and give a curative instruction. And she did that. She looked at the jury and said, the holes in the sweatshirt, were made by the forensic evaluators, and it basically told the jurors, you can ignore the evidence that had come in saying that they didn't match up to whatever it was that they were saying it didn't match up to. I thought the curative instruction is right, because when you step in and you decide to clear a mistrial, I mean, first of all, they were asking for a mistrial in a way that with prejudice, as you know, meaning that they can't bring the case back. I mean, that would have been appealed up to the SJC. Maybe the SJC would decide. Maybe it would come back, and we'd have another round of this. But most of the time, if a mistrial is declared, the question was, I think, was there enough of a trial that it would have exposed Karen Read to double jeopardy? And judges don't want to get into all of that stuff.
Right.
I mean, there are so many factors. And so I think she did the right thing in basically saying you can ignore this. And I have to say, it carried a lot of weight in the sense that it showed that you have a prosecutor who didn't know that this cross-examination that's taking place, and doesn't know that there are holes in the sweatshirt. And I think there were times when it was clear that it wasn't known that there were radiographs or x-rays showing no broken bones. I mean, I was absolutely stunned, because, months and months of work went into this, thousands of hours of preparation, and then things were missed. So, well, I thought the judge did the right thing. I don't think if I had been in a situation like that, I would have declared a mistrial, because once you do that, it brings on a whole other slew of things that happened. You saw it in the first trial. The mistrial was declared when the jury allegedly couldn't agree. I know there was some dispute about that.
Mm-hmm.
But then look what happened. Then it was appealed, and then it went up to the SJC. And not only that, they were asking the judge to do it with prejudice, meaning that it couldn't come back. Well, that's going to be appealed. No, clear it up, make it clear. The jury got it nice and clear, and then move on.
And frankly, at the end of the day, that was the best thing for Karen Read, that she did not declare a mistrial, because this was a much better result, frankly, than that, for all the reasons that you declare, whatever anybody says. And I agree that the curative instruction was the right move. I don't necessarily love the curative instruction she gave, but that's another topic. So another big question everybody basically has is, what is Massachusetts judicial oversight? Does the governor's council reprimand judges? Everybody wants to know, if we're frustrated with Judge Cannoni or some other judge, what is it that they can do? Who can they tell? What can be done? As much as you want to answer with this, you can. I know it might be a bit of a sensitive topic, but just at least what's the procedure look like, or who is double checking judges, if anyone?
Right. Well, I mean, aside from the appeals court, which,
Yeah.
double checks judges on decisions they've made. I mean, I've been overturned a couple of times by the appeals court, and other times have been upheld by the appeals court. And in my practice, I was an appellate attorney, so I'm pretty familiar with that process and what they will do and what they won't do. And that's not the route. I mean, if there's a legitimate complaint about a judge, then those complaints go to the Commission for Judicial Conduct. But you cannot complain to the Commission for Judicial Conduct about decisions that were made during the trial. That's for the appeals court, if there's a guilty verdict. So you can't really complain about this decision or that decision. I think what you have to do is you have to look up the site for the Commission on Judicial Conduct, and then it has to fit into one of those categories. I think most of the issues in this case that I saw didn't fit into so much into the complaint process as it fit into what I viewed as legitimate decisions that were made that could be overturned. And not every decision that's made that you don't agree with isn't something that would be overturned. There are certain rules about what can, it's, in other words, as it's called reversible error.
Right.
So decisions that are made have to be reversible error in order to be overturned. And so I think you would have seen a very vigorous appeal. And in my sense, I think there would have been the potential for a guilty verdict to be overturned, but you'll obviously never know.
Right.
A lot of people think, well, the state can appeal this case. And of course, we know that's not true. That's double jeopardy. But it's the Commission for Judicial Conduct. One of the reasons I hate to put that out there is because, I don't see them I don't think it's necessary to flood them unless it fits into a specific category. I mean, I will say this, one of the things that probably bothered me the most was, for example, when Alan Jackson was asking a witness question, and he was able to show that she had said something different in, I think, not in a deposition, but maybe
grand jury testimony or first trial.
Grand jury, right? And it was very clear that she was saying something very, very different. And basically, they were bringing out the fact that that what she was saying on the witness stand wasn't the truth, because she had said something completely different during the grand jury testimony. One of the big complaints I had in that respect and in other respects was the judge leaned over to the witness and said, "Was it a lie? Did you lie?" And this is what Alan Jackson was bringing out. He was pointing out very legitimately and very clearly with the rights, the Sixth Amendment rights of his client, that what that person said at the grand jury was not the same thing that the person said. And then Judge Cannoni intervened and asked questions. And the rule about that is you can't ask substantive questions that make it seem like you're on one side or the other. I mean, judges can ask questions. If I had a jury trial, I almost never ask questions unless it was to clarify. And that's the rule. You can ask clarifying questions. But there's case law that says, and I talked about this actually in another case, but there's case law that says you can't weigh in as a judge on one side or the other. So when you ask questions, and trust me, I asked lots of questions in child abuse cases because I needed to make a decision that wasn't going to put a child at risk. So I asked lots of questions, but you can't ask questions that make it appear as if you're on one side or the other. And when you have a judge who leans over and says, well, interrupts a cross-examination and says, "Was that a lie? Did you lie?" And the witness is like, "No." And then it's like, "Oh, well, she was just confused." That's not fair. And I thought that happened a number of times. Sometimes Judge Cannoni asked clarifying questions, which is perfectly acceptable. But when, as a judge, you start asking questions that put you on one side or the other, that's not appropriate.
Yeah, I mean, that was something that seemed obvious, and you picked one example. It felt like there was probably more than one example.
Oh, happened lots of times.
Speaking of constitutional rights, Karen Reed tried to add Mark Vetero in the middle of the process. What did you think about the judge's decision to just say conflict, can't join? Do you take those kinds of risks? How conservative do you want to be as a judge? What are you balancing there when making that decision?
Well, I actually agreed with the decision about Betterow. I mean, I think she had a right to have as many lawyers as she wanted. And, you clearly, Alessi and all of the lawyers are just amazing lawyers and with all amazing reputations. And she had really, truly an excellent team. The reason that I agreed with the decision on Betterow is because he is representing someone that was a part of it, Aidan Carney, who was, was sort of a part of this whole process and has his own charges pending against him for intimidation of witnesses related to the Reed trial. And the two cases were very intertwined, so intertwined that Aidan Carney was actually on the list, on the prosecutor's list. And so when you have that connection there, it was very hard for me to see how he could be a defense attorney when he was representing someone who was on the witness list, and in a way where there were a lot more facts. And so I mean, I have read some of the things he wrote. I've agreed with certainly with some of his analyses on the case, but he's still representing. Now, he could have gone if they called his witness. He could have been there to represent his witness, but to be on the team representing Karen Reed when it was inextricably connected, too inextricably connected, to say that it was, it was it would be the right thing to allow him in. So that's one decision I agreed with, just because the connections there were so strong. I didn't know how you could separate that out with him as part of the team.
What did you think about the verdict forms? How involved do you usually get as a judge if lawyers just agree and send you one? Are you telling them, no, you got to change X, Y, and Z? What were your thoughts there?
I had a lot of thoughts there because that was one of the things that was a problem in the first case, which is why, they maybe didn't know how to fill out the verdict slip. I was perplexed as to why the verdict slip was, and as she said, no, it's considered. She found that it's considered appropriate. I thought the objections by the defense, and once again, that little person sitting there, that little Sixth Amendment hanging over the heads, that you have this verdict slip that doesn't say not guilty on every lower count. I was stunned by that. So you have the major count, which of the second charge which was, I think, voluntary manslaughter. And then there's sometimes the lawyers will say, Judge, we want lesser included in this. So there was voluntary manslaughter, then involuntary manslaughter, and it went down the list until it got to the final charge,
Leaving the scene. Yep.
DUI, the
Oh,
DUI
the
charge.
DUI. Yeah, the bottom one. Yep.
Right, which was the bottom one. So there were 5 altogether, and at the top, it's it's asking, is the defendant, and there's a line, guilty or not guilty, and then it's listing the lesser charges, and the lesser charges didn't say guilty or not guilty, and she took the position, no, look, it says it at the top, and I was like just perplexed by that. I mean, I understand the lesser included charges, but it's you have the main charge, in the indictment, and it's guilty or not guilty, and then you're listing all these lesser included offenses right down to OUI, and none of them say guilty or not guilty. It was just I don't I still to this moment cannot figure that out. And then they eventually changed the wording, I think, but I don't know that they ever said guilty or not guilty. But eventually, after I think much pressure from the defendants, but I just don't know why the verdict slip was listed that way. I mean, from my perspective, and I didn't do murder trials because that's the only thing we didn't do. We did attempted murder and manslaughter and all of that, not very often in my court. But this is a murder trial. So, and how many people, other than you as a lawyer, how many and people who aren't lawyers have seen a verdict slip? No one. And
Yeah.
so, for a verdict, the verdict slip has to be very clear. Okay, these are lesser included offenses. Um, Involuntary manslaughter, guilty, not guilty. And as it went down the line, guilty, not guilty, not just a line there. I was just absolutely stunned by the verdict slip because people have to understand that all the people on the jury are lay people. They've never seen a verdict slip. They don't know what a verdict slip is. There was confusion about the verdict slip in the first trial, and that's what led in part to the mistrial and jurors coming out afterwards saying, "Well, we didn't know we didn't know if we could, check, how to check things out." And there was even a question in this trial where they asked about that, which showed that they were confused. And then there were changes made to the verdict slip, but not the changes maybe that I would have made, but the jury figured it out. And it was clear when they asked their question, because when they asked their question, they asked about when they were asking, it was clear that they were going to find not guilty, because the only question they asked was about the OUI, because the question about the OUI had to do with the time the initial drinks happened, and then 5 o'clock in the morning when Karen Reed was driving home. So you knew that they were laser focused on the OUI and the timing, because as you know, it goes to when a person drinks as opposed to when they're legally intoxicated. Those are two different things.
Yeah. It's, to me, sometimes lawyers make things difficult, and then once it hasn't been overturned on appeal, we're just going to stick with that. And it just doesn't make sense a lot of times. And I try to, and it's really hard to change things in the law. And when I sit in some of these rules committee meetings, I'm like, guys, this is so complicated. Why are we making it so complicated? Let's just make it simpler. But Mitza May asked, Judge Cannoni sealed all the sidebar transcripts and may intend to keep them sealed. Is that lawful? Can the public do anything to get them unsealed?
Well, I think, certain, I think there are motions that can be filed to unseal records. I'm not sure what the purpose is. It's one thing if you're going to seal like information about the jurors, like the juror slips, those are sealed. No one ever sees those, and that's the way it should be. There's a lot of personal information on the juror slips. When you're going through and selecting jurors, you're reading this personal information about them. I am not sure what the basis for sealing the sidebars. It's part of the case. The case is over. It's not going to be appealed. And so because it's not going to be appealed, I'm not sure why in a trial court, that's not a confidential court. So, if it were my court, in the juvenile court, I would be saying, no, I'm not going to release any of that because this is a sealed court. It involves children. By law, the courtroom is closed for certain types of crimes. But there's no law there that I can see, and I don't know, because I'm not necessarily sitting in and hearing adults on child abuse cases, but I'm not sitting there. But I'm sorry that I can't answer the viewer's questions because I just don't know what the basis of sealing that is, unless there were times that maybe there was a discussion about jurors at one time, they swapped the seats of jurors and they might not want that. But to generally seal them, no. And I think that what you're going to see is, I think you're going to see journalists and media outlets petitioning to unseal those unless the court can explain exactly why it's keeping information from the public.
Yeah, absolutely. We only have about 5 or 10 minutes left here, and I wanted to talk about a couple things before you left. Joe Ellen said, "Thank you for what you're doing for Harmony and her brother. I'm ready and willing to start calling and emailing all the dignitaries and demand that change is needed." Why don't you tell everybody a little bit about your connection to the Harmony Montgomery case?
Yeah, the Harmony Montgomery case, of course, is a case in Massachusetts where Harmony was in custody almost shortly after birth for 4 years and 9 months. And both parents had been declared unfit. The father had been in jail numerous times and had a very violent history. And they filed a petition. They had been found unfit, but their parental rights weren't terminated. And so, because their parental rights weren't terminated, they could go before the court and ask the court to reconsider. And that's what happened. I write about it, and I write all about this in a book, how the motion for reconsideration trial was heard in 6 hours, and that the mother was in another court, which I didn't view as fair. But Harmony was released to her father, who was a long-term substance abuser, violent criminal, history, long history. And then he had her for 6 months. The mother was to have visits. He cut those out. And uh, 6 months, I think, well, it was in February, he was granted custody. And just before Christmas, they were homeless because of their substance abuse. And she was in the car and she wet her pants because he was very violent toward her. And he reached back and started beating her over and over and over and over again in the head until she died. And then he took her body, and we still don't know where it is, but he kind of dismembered her body and hid it in various places. And my connection to the case is that maybe 2 years before that, on National Adoption Day, I asked a news media person who had adopted two kids. He and his husband had adopted two kids, and I said, "Why don't you come and speak, to this huge crowd on National Adoption Day?" His name is Blair Miller, and he has been a reporter in Washington D.C. He's now the chief anchor in Atlanta. And I said, you can take one more child. Why don't you consider taking another child and adopt a kid from DCF, from the state? And so they sort of took that advice and called me several months later saying they had been through the process and had been vetted and they were going to adopt this child. They adopted this little boy named Jameson, who's a wonderful little boy. And the Chief Justice allowed me to do that adoption on National Adoption Day. And that was in November 2019. And 1 month later, the father beat Jameson's sister, who is Harmony Montgomery, to death in that car. And so that's my connection to the case. And it's had a stunning impact, of course, on their lives and on Jameson's life. And we're fighting a lot of people in the government to make changes in the child welfare system. And I have recently been in touch and am filing a petition with the FBI to take a look at how New Hampshire treated the child. A lot of violations of our constitutional rights, where the department made many mistakes, didn't even really respond to the fact that she was being beaten in that home by her father. There were 17 child abuse reports filed, pretty much ignored by DCF. And after the last one in October of 2019, they declared that there was no abuse or neglect. And 7 weeks later, he beat her to death.
Wow.
And so I've decided to move to the federal agencies and ask the federal agencies and the U.S. attorney to evaluate it for violations under federal law to see if we can get somewhere. So that's really kind of my mission now, and that's really what I'm working with the two dads to accomplish.
And you also wrote a book, is that right?
Yeah, the book I wrote is called I wrote a book about the lack of injustice to Harmony, and it's called A Cruel Injustice. And it's how and there's a subtitle about how Massachusetts put Harmony Montgomery in harm's way. And it just goes through the mistakes that were made by the Department of Children and Families. The mistakes I didn't have too much blame for the judge, not because I was a judge and not because I knew that judge, but because the Department of Children and Families only presented one or two witnesses. The trial for this child who had been in state custody for almost 5 years, it was a 6-hour trial. and they handed custody to the father, even though they knew the mother couldn't make it. So I wrote a book, just sort of outlining the problems in the system, strongly criticizing the Massachusetts child welfare and legal system related to children, which is why I say I'm somewhat persona non grata, somewhat, with the Massachusetts judiciary, because people don't like it when you sort of reveal the secrets from inside the system.
Where can people find the book?
Oh, Cruel Injustice, it's on Amazon and it's on Barnes and Noble. I donate every cent of that to the Dave Thomas Foundation for Adoption, to their section that finds adoptive homes for hard to adopt children that have disabilities, siblings, older children. So I wrote the book, and I made a decision with Blair and Jonathan to donate every cent of the proceeds to the Dave Thomas Foundation for Adoption, so that they can help find homes for children who are sort of lingering in custody.
Okay, awesome. What we're going to do, Kelsey, you're on there. Why don't we have like the first 10 people that email us in that want us the book, we'll buy them the book from Amazon. We'll get the link, send it out there to some of them, and encourage everybody else to go buy the book that's interested in it. I mean, I didn't follow that Montgomery case. I heard a little bit about it and people talking about it. Really, really wild story. And thank you for what you've done already and what you're continuing to do there. And I really appreciate you coming on here. I really appreciate you sharing your insight with us. I know I learned so much in this interview, which is always my goal every time I sign in here to YouTube, is hopefully I can learn something. Hopefully everybody else did too, but I really appreciate you taking the time today.
Thank you. So grateful to you for giving me the opportunity. And it's just something that I haven't done very often, but I really appreciate it. And I want to thank my stepdaughter for pushing me to do this particular interview. I really appreciate the way you handled it. Thank you so much.
Yes. And hopefully we hear more from you, because I really think it's a good perspective to just professionally discuss differences. I mean, you agreed with some, you disagreed with others. That's basically how it works in the law, right? We're not all going to agree on everything throughout the process. And I think you explained discretion perfectly. I really appreciate it. Hopefully you guys in the chat learned something. Everybody hit that like button and make sure you're subscribed. Until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast, with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.